Mr Chair, Mr Chair, Mr Chair.
David Clement.
Chair, I'd like to reflect on something Mr Naro said. He made a statement I can agree with, and that's not always the case, I have to say, but he did point out, he talked about a different scale of offending within overall, I hope I don't misunderstand him. He talked about an example where a 19-year-old might have consensual sex with a 15-year-old. Undesirable behaviour, something that needs to be dealt with. It's not condoned, but a very different scale of offending to someone who assaults an infant or a young child. Therefore, we would deal with those people differently. We would assess the risk of their reoffending differently, given the circumstances. Unfortunately, that is what this legislation abjectly fails to do. This legislation, and I'm going to quote here, the legislation currently before this committee, this is written in November last year, assesses offenders' risk on the basis of offence type rather than their risk of reoffending. The ever-reliable Kim Workman offered us a supplementary submission to the committee on behalf of Robson Hannon Trust, and made a very valid point, I thought, that we have in this legislation an expectation that people who commit particular types of offences therefore share a similar risk profile. And that's demonstrably untrue. There are people who will commit certain offences who are highly likely to go on and reoffend in that same style of offence. There are other people who might commit an offence who are most unlikely to reoffend for whatever reason. One of my first excursions into visiting people in the community with some interesting record, I went to a relatively remote place and spent some time with a man who'd done time for attempted murder. And on the way out, I thought, this is an interesting situation to go in. The fact is, having got to know and talk to that man, the likelihood of him reoffending was probably zero in that particular offence. Similarly with some sex offenders. The submission from Mr Workman was titled Risk Assessment of Sex Offenders, A Short History. He talks about 1995 as a bit of a turning point in how we deal with risk assessment generally, and it was in the context of decisions having to be made by parole officers, but it's perfectly valid for this as well. And the key finding he comes to is that this is a one-size-fits-all approach. It does not facilitate or encourage person-by-person individual profiling the risk of reoffending of each individual as we go through. And that's fundamentally the wrong approach. It causes me to reflect on the much better solution that was offered by the Law Society, who opposed this bill, they opposed this legislation and continue to, not dismissing the fact that we do have a problem in this country, but suggesting a much better alternative. Not this blanket approach, you committed offence X, therefore you go onto a register potentially for life, but simply giving judges the authority and the wherewithal to make single judgments in specific cases to say, yes, on balance, the likelihood of this person reoffending is very, very high, and therefore they ought to be identified in an ongoing way in the interests of community safety. That's a far more sensible approach than this one-size-fits-all blanket approach. You've offended against law X, therefore we're assuming you'll continue to offend. There's simply no justification for that sort of blanket approach to risk assessment. New Zealand, and Mr Workman notes this, has developed quite a good reputation. We haven't got it right yet, clearly. We get it wrong on occasion. But we're seen as having been at the forefront of modelling new and improved ways of assessing the risk of people reoffending. And this is a retrograde step. So we could potentially support any mechanism that we believed was going to reduce the likelihood of offending against our children, that might protect our children. Sadly, we believe the only protective element is in the name of this legislation. The New Zealand Family Violence Clearinghouse, who have done a lot of research around sexual violence, domestic violence, could find no compelling evidence anywhere in the world that suggests that a register actually does enhance protection of children, that it would be effective in any way. That was a theme to a lot of the, dare I say it, the better informed submitters. We heard anecdotal reference to research or reading or something somebody had heard somewhere that indicated that registers do have some facility to protect, to lower the risk to children. We could see no substantive evidence.
Oh, Lewis Award.